Hi, I'm Karl Konrad and welcome to the weekly edition of Australian Immigration News. This show is proudly brought to you by Australian Immigration Law Services here in Sydney, the company I founded more than 24 years ago. Tonight we have a special edition devoted to the 191 Permanent Residency Visa. But even if you're not using this visa, the story demonstrates how at times we have to battle with the Immigration Department to get to the truth. In last week's edition, we demanded Andrew Giles, the Immigration Minister, tell us what's going on with the 191 visa requirements. There is mass confusion out there, with some lawyers and migration agents saying the Regional Provisional stream of the 191 visa is not tied to the TSMIT, and some saying that it is. Despite this controversy, the department is publicly not saying anything, which only fuels the debate. Tonight, we can reveal that the Immigration Department themselves are confused about what is actually going on. We have a letter from the Minister's office saying one thing and one from the Skilled Migration section saying something completely different. So sit down and make yourselves comfortable, for we take no responsibility if you faint while standing and watching this on your phone. Our regular viewers know that we were the first to publicly criticise the Immigration Department for the misinformation on their 191 visa website regarding the so-called 3-year residency requirement of the Regional Provisional stream. Now, this has been fixed after years of leaving such incorrect information in the public arena. If you missed that video, we will leave a link at the end of this one. Now, 491 visa holders are confused about what is the minimum income requirement, thanks to Claire O'Neill's announcement during her speech at the National Press Club regarding raising the TSMIT. We also have those who have lodged the 191 visa in the Regional Provisional stream more than 6 months ago and none have been granted. This is compared to those who applied under the Hong Kong stream and received their PR already after 1 or 2 months. Now it's time to expose what has really been going on behind the Immigration Department's closed doors. They seem completely confused about what has gone on in the past to bring us to this point, and confused about what direction 491 visa holders can expect when trying to apply for their 191 visa. I have 2 of our viewers to thank for their efforts to bring their own results to our channel to publicly release, Dushyant and Ali. First to Dushyant's efforts. He tried to get the Immigration Minister's attention on many fronts and finally succeeded to get a response using the department's complaint form. I asked Dushyant to come on the show to share his experience and his results. Thanks, Dushyant, for the information you sent me and for agreeing to speak on the show.
Thank you so much for taking the time out. I know, I think you're a savior for a lot of people. Your YouTube channel keeps everybody informed with, so many visa changes and regulations. So kudos from my end. Really appreciate all the work you do.
I appreciate the feedback, Dushyant, and thanks so much for your support. Now, you and your wife hold the 491 visa and are preparing to lodge for the 191 visa. Is that right?
Me and my wife, we applied for 491 visa back in 2020. March is when we applied it, and it got granted in June 2020, June 26th. So we're just going to be applying for 191.
So what were you originally told about moving from the 491 visa to the 191 visa?
We were told that it's going to be a streamlined transition to a PR. Like, once you are on 491, you do your bit in regional Australia, pay your dues, and then it's going to be a seamless transition. You just need to apply for 191. Don't have any more hurdles that you need to jump through.
So you were concerned about the lack of information on the department's website and why no 191 visas had been granted in the regional stream, and you lodged your complaint. Were you ready for the answer that came back?
It's shocking as an applicant. You invest so much time and money. You go through a pathway. You assume, the government, the department is going to look after the rest. You leave it on them. I'm not a lawyer. I'm an engineer. This is not my job.
Now let me put up on the screen the contents of that email so our viewers can read them. And by the way, everyone, I have made a copy of this you can download in the description of this video. The personal details of Dushyant have been redacted. In this email from the Skilled Migration section, it reads, "There have been many assumptions made by the community and migration agents in relation to the subclass 191 income requirements, and many people have incorrectly associated the income level for the subclass 191 visa to be the temporary skilled migration income threshold, the TSMIT. At no point has the Australian government nor the department indicated that the income level will be tied to the TSMIT. TSMIT is relevant to the subclass 482 TSS visa and some other employer-sponsored visas." Well, is this statement true? Well, the first sentence is completely incorrect. We have not made any assumptions at all. We have just paid attention to the department's own September 2019 newsletter, which states, "The minimum taxable income for the subclass 494 and 191 visa will be set at the temporary skilled migration income threshold, the TSMIT." And how about that second claim? At no point has the Australian government nor the department indicated that the income level will be tied to the TSMIT. Well, that's a lot of waffle too. When they said that the income level will be set at the TSMIT, it has the normal implication that when the TSMIT rises, so will the minimum income level. In fact, the only thing true in this paragraph is the last sentence. TSMIT is relevant to the subclass 482 TSS visa and some other employer-sponsored visas. So what is the minimum income level meant to be then, if indeed the 191 visa is not set to the TSMIT at all? Well, according to their letter, you are correct that there is currently no legislative instrument for the income threshold for the subclass 191 visa, and as such, there is no minimum salary requirement to meet Regulation 191.222. There you have it. The department's answer is categorical. There is no minimum income requirement needed to meet the Regional Provisional stream of the 191 visa. So has every 491 visa holder been striving for years to meet the minimum income level of $53,900 and been wasting their time? Well, I'm afraid according to this email, it seems they have been. In the current circumstances, you can lodge the 191 visa if you meet all other requirements and just show 3 taxable income returns showing 0 taxable income level. However, before you get either very angry about this or very excited, or you are just frustrated and more confused, let's take a look at what Minister Andrew Giles' representative had to say when asked about the same issues. And thanks to Ali, who wrote into the Minister and received this reply. The subclass 191 visa eligibility criteria requires, amongst other things, that applicants have lived for at least 3 years in a designated regional area and the applicant's taxable income for at least 3 income years prior to lodging the application. The taxable income is shown on the Australian Taxation Office Notice of Assessment. The minimum taxable income for the subclass 191 visa is set at the temporary skilled migration income threshold, currently $53,900. As you may be aware, the Australian government has announced there will be an increase to the TSMIT. A redacted copy of this letter can also be found in the description of this video. So here we have the representative of the Minister, Andrew Giles, telling us there is a minimum income level set for the 191 visa and it is set to the TSMIT. It goes on further to indicate that the 191 visa is tied to the TSMIT as he refers to the upcoming increase. For the moment, we will just ignore his incorrect statement claiming the 191 visa in the Regional Provisional stream requires 3 years of residency. So here we have 2 completely conflicting pieces of advice. One tells us there is no minimum income level and one tells us there is. And this income level is not only set at the TSMIT, but it's also tied to the TSMIT. It is not the migration agents, the lawyers or the community who are confused. It is the Immigration Department themselves, and that is why we are all consequentially confused as well. And it is people like Dushyant and Ali and tens of thousands of others out there who are very worried about what is going on. So overall, Dushyant, how does this contradiction make you feel?
I still feel the government has, or the department has sort of let us down. Like they're not being very clear. Have the problem that we don't have a line of sight on when we're going to get our PR.
Yes, clarity is indeed what we are all seeking here.
Even at this time, government hasn't taken the opportunity to give more information on 191, and they're still pumping out the 491 grants. Like that's not fair. That's not ethical. When you don't have a successor in place, how can you give people a 491 visa?
Yes, exactly. And to rub salt into the wound, they have been granting permanent residence to the Hong Kong Stream 191 visa applicants, but as far as we know, still not a single regional provisional stream application has been granted.
I feel 191 would be in the same category regardless. So Hong Kong applicants and regional applicants should be in the same, at least, order of processing. Then how is it that those that specific visa subclass is getting their visas much faster than the regional pathway visa applicants? It doesn't make sense in my head. Look, analytically as well, at least one should have been granted.
In the end, Rashant, all you want is to be told the truth and not told two completely contradictory pieces of advice from the one government office. More people are asking questions now and seeking clarity about their future. Are we going to get more and more conflicting versions of the truth from this government? Will anyone from the department come forward and actually own this mess?
You can deny all the things I've seen, all the things I've discovered, but not for much longer. Because too many others know what's happening out there. And no government agency has jurisdiction over the truth.
We know out there are tens of thousands of people affected by this uncertainty. Families who've moved all their children to the regional areas and doing the right thing. Many have been working 2 jobs just to meet the income level, which may not have even been necessary. The Immigration Department has a lot to answer for, and it's time, Andrew Giles, that you stood up and demonstrated leadership over this debacle and not push it off to someone else to answer for you. Thanks so much for joining us tonight, Jashant, and sharing your experiences.
No problem, Karl. Thank you so much, and hope you have a great night. Thank you so much.
No worries. It's all part of the community service. Thank you. So to all of you who have stayed to the end to watch, a big thank you. I'm sure this mess will be sorted soon, and I have a hunch they may in fact leave it at the 0 income level just to make sure no one is disadvantaged by the misinformation the department has been spreading. Stay tuned to our next week's riveting edition, where we have the Trade Recognition Australia in our sights for their mismanagement of the skill assessment process. As always, take care out there, and I'll see you next time. So bye for now.